I'm David Ward. I'm a staff attorney at Legal Voice, although my formal title is Legal and Legislative Counsel, which is a bit of a mouthful, but it does reflect the fact that our jobs at Legal Voice are not only to do litigation, but we also have a very long-standing and active legislative program in Olympia. And we're here today to give you a preview of the 2016 legislative session. Pamela Crone and Nancy Sapiro will start and give an overview of what to expect in the session, and then Janet Chung and I will go over some of the legislative priorities that Legal Voice expects to be working on this session. So, folks sitting over there, I'm sorry you're not going to be able to see the slides so well, but we'll let you know when we're flipping a page, so you can follow up. Yes, they're very detailed slides. So, okay. So with that, I'll turn it over to Pam and Nancy.
All right, so we'll go ahead and look at the first, oh, I have control over this. Whoa, there we go. We'll go ahead and look at the first slide. There we go. We already did introductions, at least insofar as Nancy and I and David will hear from Janet later on when she speaks. So yes, Legal Voice has a legislative program. I see lots of people I know, so just have to look around and say welcome to everybody. Many of you joined us when we did a debrief on the 2015 legislative session. We are going to talk a little bit about that, just to establish some context for 2016, but we're going to spend most of our time in a preview of 16, as well as the Legal Voice issues that we will be supporting and championing, and in many cases leading on in Olympia. So we start working on a legislative agenda well before the session begins. This year was a tricky one because we did not get out of Olympia until July 13th. And the session should have been 105 days. It instead was many more than that. We actually went into a third special session, and the operating budget was signed on June 30th, just about an hour or so before July 1st, when the new fiscal year was to begin. We've had a lot of these sessions where we've gone a very long distance to be able to accomplish the basic business of the state. So customarily, as soon as we finish with a legislative session, we start thinking about what we're going to do in the next legislative session. And we're all involved in that. So that's, David and Janet as legal and legislative counsel. Lisa also participates, and then Nancy and I. And Nancy and I really contribute the political piece and the strategic piece to the conversation, and then we think about what it is we'd like to accomplish long term, and then just what we might be able to do in a given legislative session. In our work, we do affirmative work, even during sessions that have looked very grim. We have tried to have a proactive agenda as well as a defensive one. The defensive work is every bit as important as the proactive work. We do try to make sure that we have a proactive agenda so that we are not wholly dominated by defensive work. We want to be pushing the envelope. That's what Legal Voice is, and that's what Legal Voice does. So just a very quick look back at, I keep turning my microphone off and David keeps turning it on, thank you. A very quick look back. Again, we just finished a very long session, and much of what the legislature needed to accomplish in 2015, unfortunately, the legislature still needs to accomplish in 2016. The McCleary obligations, I think most of you are familiar by this time with the McCleary decision from our state Supreme Court, finding that our state is not meeting constitutional requirements around funding basic education. And since the time that there was that finding, there's been additional activity. In a nutshell, the legislature has made some down payments. And they actually created a number of years ago, Senator Chase is here. Just want to welcome her and thank you for participating today. The legislature has made a number of down payments on McCleary, but doing the full deal, not just determining how to fund basic education over the long term, they also have to figure out what the mechanics for funding basic education will be. And that has to do with the way that we basically fund education now, and that's by local levy. And that is really problematic when you're looking at very property-rich districts versus those that are less property-rich. So we have not just the potential, but we have a school funding mechanism that really isn't a mechanism. We have some districts that are able to perform really well and others not because they're essentially starved for funds. So what has happened over the interim, and well actually prior to the interim, just when the 15th session ended, and the court was dissatisfied with the progress that the legislature and the state had made on McCleary, they had already found the state in contempt. And so they decided to put a little bit of, meat around the bones of the contempt citation in order by assessing a fund that would go eventually as a down payment to financing the schools, a fine of $100,000 a day. And that did prompt some activity in the legislature. The governor put together a work group with suggestions from all 4 caucuses. There was a listening tour, and if there are time for questions at the end and you want to hear a little more about McCleary, we can do that. But leading into 16, and Nancy will address it a little bit too, we are accumulating this fine of $100,000 a day. There was also, during 2015, the issue of Initiative 1351, which had passed. That was a class size initiative. McCleary does reduce class size, but it reduces class size for K-3, and the initiative would reduce class size through grade 12. The legislature did not fund that initiative, and in fact, they voted, and it required a 2/3 vote to suspend operation of that initiative. During the session, when we went into the session, there wasn't going to be enough money, and there seemed to be some really serious conversations about taxes. As the revenue forecast came over several months, the revenue picture improved, and unfortunately, any conversation that anyone was having about raising taxes and creating a sustainable budget and certain revenue stream went by the wayside. So we had a lot of success as an organization in 2015. That's kind of the context and the backdrop, and it sounds like all gloom and doom. Well, I gotta say, Legal Voice really kind of rocked it. So we're gonna turn to Nancy, and she's gonna talk just a little bit about some of those accomplishments, a little bit more about 16, and then we'll dive into our issues for 16.
Oh, great. Thanks, Pam. Well, as Pam said, there was a lot going on in the 2015 session, and one would think that between all the budget challenges that the legislators are facing, the McCleary obligations, Initiative 1351, there were a huge transportation budget that needed to be passed, there was marijuana reform that needed to happen, and so you might think that really not a lot of substance happened on a policy level, but as Pam said, we really had an incredible year and many, many successes. So just very, very quickly want to tick through what a few of those were, because we're still kind of celebrating. First, what you can see is rape kit testing, which is House Bill 1068, and this bill essentially requires law enforcement agencies to submit rape kits for testing to the Washington State Patrol Crime Lab, and they need to do that within 30 days. I think there's been a lot in the press in the past month, so I'm sure you all have some familiarity with this, but at one point, this Washington State Patrol estimated that there were more than 6,000 untested kits in the state. So the bill that passed won't deal with those untested kits that are sort of sitting on the shelves. This is only sort of prospectively looking forward, trying to ensure that those tests that are acquired, that they are tested in a timely manner. There is also a work group that was formed, though, as part of this legislation, and they are tasked with trying to come up with mechanisms or grant money and other ways that we can somehow try to reduce that backlog and get some of those untested kits tested. And I don't know the current status of that. People have questions. I bet David does.
Yeah. They've met twice so far.
Okay.
And, yeah.
So that is one that we're very excited about. The other are the two non-consensual pornography bills, sometimes referred to as revenge porn. And there was a criminal bill as well as a civil bill, and both of them create more effective remedies for victims of non-consensual pornography. It was just a ride with these two bills. We ultimately did not get them passed until the third special session, and I think we put David through emotional whiplash. We would call and say, okay, everything's taken care of, we've got all of our T's crossed, and it's going to happen, and an hour later we'd call and say, never mind, the bill is dead, and then we'd call an hour later and say, no, it's back alive. And, it really, more so than any bill that I have worked on, I don't know, sorry for Pam, but it just sort of the back and forth and whether it was going to happen or not happen, and things popping up. It was amazing, but we are thrilled that both of these bills passed. And oh, yes.
During the last meeting, you guys hadn't passed it yet, and I was wondering if you were able to get in language to protect minors, especially for like the criminal aspect, so that they didn't get charged with child pornography.
There is language around minors, and David, please step in here.
There is language in the bill that provides that if a minor, are you talking about the perpetrator who's charged, or yeah? For the perpetrator, it has to be shown that if a perpetrator is under 18, that it was distributed maliciously. So there would, in fact, they'd have to show, at least under the statute that we passed last year, for a minor to be prosecuted for the new criminal law, the prosecutors would have to show that it was distributed maliciously. It would not cover, sexting where people are consensually trading pictures of themselves as minors. However, I mean, technically that is still could be viewed by some prosecutors as a violation of long existing child pornography laws, and the bill did not address that. I think the good news is we haven't seen a whole lot of cases that I'm aware of in Washington where prosecutors have gone after teenagers for consensual sexting. I can't recall any, but it is, technically they still probably could. So that might be another issue to look at another day to address those if problems arise.
They actually are charging, and the ACLU is working on those cases.
Okay.
Yeah.
Thanks for Leslie's
Sorry
contribution.
to bring me on that, but yeah, prosecutors are charging minors for sexting.
So third bill, or bills, there were two bills that came out of the Senate regarding campus sexual assault. One was a study bill, and the other attempts to create some uniformity around the campus's response to sexual violence. I'm sure we've all read in the paper about various cases throughout the country where athletes perhaps are put through a different process than others when there are allegations of sexual violence, and this is an attempt to try ensure that there is a uniform process that is applied finally, there was a good cause exemption bill. This was essentially a continuation of a bill that had been passed a couple years earlier, which was set to sunset, and it arises in the child welfare setting. There are some pretty strict timelines laid out in statute as to when the state needs to move towards termination of parental rights. And what this does, in essence, is create two exceptions to that, saying that if a parent has been accepted into a treatment program and they're making good progress, that might be a reason, and they're in compliance with the treatment program, that may well be a good cause reason to postpone filing a termination petition. And also in those situations where a parent has been ordered to participate in services and they don't have the financial resources to pay for them, that the inability to pay in and of itself should also count as a reason as to why there might be a reason to delay filing a termination petition. So those were just some of the highlights that we were able to accomplish last year, and amongst everything else that happened. And I said we were very, very excited about that. That brings us to 2016. Session begins very, very soon on January 11th. This is intended to be a short session. It is supposed to be 60 days. What they have to do during this session is if there are any variances, any changes they need to make to the budget based upon the biennial budget that they passed last year, what they do is they pass a supplemental budget to account for those variances. There is going to be a need to do a supplemental budget if for nothing else. As I'm sure you all are aware, there were raging wildfires this summer, and the amount of money that was allocated to pay for forest fires was not sufficient. So there was an over expenditure, and so there needs to be additional money allotted for that. Every quarter, I believe it is, there is a budget forecast that comes out, and a budget forecast came out in mid-November, and the budget looked pretty good as far as the 2-year budget. At this point, given the revenues that are coming in, it shows that there might be a surplus of about $357 million for 2015-17, and while that is good news, when they project out 4 years, for that 4-year projection, it shows that there's a shortfall of about $474 million. So long-term things don't look so good. So there will be, as I said, will be a need to do a supplemental budget. There is talk among many that what they intend to do is to go down to Olympia, pay the bills, and go home. That there's not going to be a lot of policy that is going to happen. We shall see. We certainly hope there are policy things that can happen this session. We intend to advocate for that. Part of the reason that there's motivation to actually have this be a 60-day session is we have elections coming up in the fall. The entire House will be up for re-election, and 1/2 of the Senate will be up for election. Legislators are anxious to get back home, to get to their districts, to be able to be getting out to their communities, talking with their constituents. They also are prevented from fundraising while they're in session. So there are multiple reasons why legislators don't want to do the people's business and get back to their district and start their campaigns. Anything else, just big picture?
Just the, maybe the political piece.
Yeah. So, there was an election this fall, as I'm sure you all know, and the composition of the House changed by 1 seat. It had been that the who are attending charter schools, and the court has said these schools are unconstitutional. So question remains, will the legislature do something about that? Will they attempt to modify the statute in some way to try to make it constitutional? What are they going to do? Are they going to put funding towards it? All that remains to be seen. And then there is this minor initiative that passed in November 1366, another Tim Eyman initiative, which could have some very, very significant consequences for all of us. In essence, this initiative basically says that it will cut the sales tax from 6.5% to 5.5% on April 15th, unless lawmakers put a constitutional amendment on the ballot that will require a 2/3 vote to increase taxes. It essentially holding the legislature ransom, and really puts them in a very untenable position to either choose to immediately cut, impose a tax cut, or face the prospect of close to $1.4 billion per year. $1.5 billion per year sort of cut in revenues that are going to come in. A lawsuit has been filed challenging the constitutionality of this initiative. That is in the works. I think it's unknown whether there will be any word from the court prior to April 15th, and so it raises the question of how folks in the legislature are going to handle this initiative looming over their heads. So that's a big one that everyone needs to be concerned about. Yes?
There is a hearing set in King County Superior Court in that case on January 19th.
Ah, thank you.
For Judge Downing.
For
Oh, Judge Downing,
Yeah.
okay, thank you.
Ah, wonderful, that's great. So with all of that as background, you kind of have a sense of what they were able to accomplish last year, what was left undone, the things that they have to do, must do in 2016, these other large looming issues that are hanging over their heads. And with that, we will move to sort of the substantive policy work that Legal Voice wants to be working on this session.
Okay. There we go. Can you hear me? So I'm Janet Chung, and I'm going to talk about first one of our issue areas, the health and reproductive rights arena. And of course, there is, a little bit of a false division. Sometimes there's a lot of overlap among these issues, but so bear with us with our the way we divided them. But let's go on to the health and reproductive rights. So I think Pam and Nancy, thank you very much for giving us that context, because I think it's really important. We always appreciate the reality check, when we're thinking, but look what California did, and can we do this? And they're like, yes, but they've got, their supermajority, and they've got, Democratic control of both houses, and so, there's always that kind of reality check. But I guess I'd like to offer a little bit of context before I talk about the specific bills, both about Washington existing law and just kind of what's happening around the country. So I think it is not an understatement to say that health and reproductive rights have been under assault in many places in the country, both in the legislatures and in the courts. The good news in Washington is that we do have strong statutory protections for reproductive rights. Back in 1991, by voter initiative that our fearless leader, Lisa Stone, helped draft this initiative that essentially codifies Roe, and it creates a fundamental right to both birth control and abortion in our statute. So that has really, turned out to be a bulwark, I think, against a lot of the kinds of attacks we're seeing elsewhere, because it's already there. So we've got that going for us. We also have contraceptive equity ruling from our insurance commissioner, again, challenges was as a equality issue, that, you know, gosh, if insurance companies were covering drugs, prescription drugs for men that were just for men, things like, of course, Viagra, and that was the kind of the headline issue, then, you know, really they ought to be fairly covering prescription drugs for women as well, including contraception. So that was really the framework. And so we do have a rule like that on the books in our state. And then, of course, we have the ACA passage. So we've got a lot of good protections in our state already. And I want to also mention, you know, we're focusing on legislative advocacy today, but there, of course, is the interplay with the courts, as well as a lot of administrative rulemaking that is relevant as well. And I just want to give a shout out to the work that David has been doing along with the Coalition for Inclusive Healthcare in our state on ensuring transgender health care is covered under Medicaid as well as state employee benefits. And that's been actually pretty, you know, I don't think it's been very much heralded, but it's been really significant. And Washington's again been a leader in ensuring that that's what we mean by avoiding gender discrimination. It's including all kinds of health care in all of our benefits plans. So that's kind of the good news. The bad news, I guess, is of course what's happening elsewhere in the courts and in other states. We're seeing a lot of restrictions on just the right to coverage and just really chipping away at, for example, many states are banning insurance coverage through both their public insurance plans, so Medicaid and the like. We've got federal restrictions like that as well. But again, because of our state statute, we don't have that kind of issue with our Medicaid plan. Our Medicaid does cover abortions on equal footing with maternity care. So that's kind of how we've got it protected here in our state. Okay, so given all that, I think this is all just to say that we actually, even though sometimes it feels like the sky is falling, we are doing pretty well at holding the line in Washington, and we're trying to push the envelope, as Pam said, and be one of those states that can improve access. Because I think what we're seeing in Washington anyways, we've got these rights on the books, but we still see a lot of inequity in access to coverage. We see disparities in access for low-income people, often for communities, immigrant communities are often completely excluded from all forms of healthcare, including reproductive health, and then also incarcerated populations. So I'll talk about the contraceptive access bill. This is one that debuted this spring, and it is modeled after the California law, and basically seeks to be a backstop against attacks on the ACA. So of course everyone's heard about the literally dozens, and may even be hundreds of cases challenging the contraceptive coverage provisions in the Affordable Care Act, now pending in the Supreme Court. So one strategy to those attacks is to make sure that we've got protections in state law, because if we've got those protections in state law, employers who do not want to provide that comprehensive coverage can't seek protection under the federal religious freedom statute. Okay, so that's a whole other topic. I could spend an hour, I will not. But that is part of the impetus for trying to, again, get these protections in state law. So the bill that was introduced and remains pending for this coming session is the Reproductive Health Act. And it, again, a comprehensive bill that sought to ensure that all insurers would quite simply provide coverage for the full range of FDA-approved contraceptive devices and drugs. What we are seeing with the ACA is, despite those protections in the federal law, a lot of insurers still not complying. We are hearing anecdotally lots of folks saying, you know, I thought that I was supposed to be able to go get, you know, my contraception covered without any co-pays, without it affecting my deductible. And yes, that is true. But insurers were really inconsistent in their training, in their own systems. So people were seeing denials. They're seeing if, you know, things were not coded the right way. If your office visit for birth control coverage, for example, is not coded correctly as preventive care, you may still see a bill, and that's wrong. So the good news in Washington, again, is that was basically said, hey, insurance companies, let's talk about what's happening, and gave them basically some time to try to remedy these problems and come back and report. And as of October, a lot of them had really taken this charge very seriously and had addressed a lot of those kinds of inconsistencies that really were a matter of training and making sure that all of their consumer facing as well as bills processing folks were all on the same page about the requirements. Yeah.
I'm in the 28th legislative district with Steve O'Ban, who I have heard has joined the Alliance Defending Freedom, who was instrumental in providing protections for people that want to opt out of providing Plan B, along with, DOMA and a bunch of other stuff. But they're anticipating a lot of action this next session, again, for protecting pharmacists that don't want to provide contraceptive services because of their personal religious belief in them. Are we prepared to start working against those?
Thank you for that. Yes, absolutely. And we are quite familiar with Senator O'Ban. He is our opposing counsel in our ongoing, still pending fight to protect the pharmaceuticals that are in place. So absolutely. And I think I'm glad you mentioned it because that is really one of the attacks. I was going to get to it in our defense part of this discussion, but that, like I said, is kind of the holding the line piece, is educating folks about that. And just FYI, for those who don't know, Legal Voice is part of an alliance of sister organizations around the country. There are 5 of us who do similar types of women's rights legal advocacy in courts and in legislatures, and we jointly issued a report, forget the actual title, Michelle? Hobby Lobby, the impact, something about, anyway, focusing on Hobby Lobby and strategies moving forward, so it kind of gets at some of the things we're doing to fight back on those, what's framed as religious liberty, but is really restrictions on healthcare is how we do it. Okay, so again, just in terms of proactive, so what we're looking for really is to increase access and coverage to populations that really aren't adequately protected. So on the contraceptive, the Reproductive Health Act, so that bill that I mentioned would require full coverage. It would, it also, one of the other key problems that we're seeing is that often insurers dispense contraceptives in 1 or 3 month supplies only, and their women end up not either being able to get their prescription renewed or get to a pharmacy to pick up the birth control, and all of those kinds of sort of instrumental barriers end up adding to our unintended pregnancy rate. And so there was a study out of California that showed that even if you just extend that period and allow and require insurers to dispense 12 months at a time, you actually really have quite an impact on unintended pregnancies. And it's kind of like a duh, but I think insurers traditionally have been a bit loath to say, okay, you can have 12 months because they, basically say we don't trust women and they might change their mind, they might change their form of birth control, and we don't want to, them to get 12 months and then switch to something else and we have to pay for that. So I'm putting words in their mouth, but there have been those kinds of objections, but we're seeing the trend now being towards insurers, some of them voluntarily, including some in our state, saying, we're willing to dispense 12 months at a time. And our Medicaid program in Washington as well does that. And so California and Oregon most recently, and DC, I believe, passed laws on that issue, just asking insurers to cover 12 months at a time. And so that is a piece of the Comprehensive Reproductive Health Act that was introduced last year here in Washington. And one other piece that I'll mention that it continues to be a barrier is now we've seen emergency contraception, be available over the counter, right? So that is a great advance, and that's due to some, again, litigation and FDA rulings. But again, a barrier is that even though insurers are supposed to cover all forms of contraception, including emergency contraception, they can require a prescription. So we've got these kind of rules in conflict in reality. So what happens is you go in and you get it over the counter if you're, say, a young woman, and you still have difficulty getting it covered because you don't have a prescription. So it kind of this bill also suggests is that, for all forms of contraception, that means you shouldn't have to have a prescription, for contraception to have it covered. That is not in the federal law. Yes.
So this is SB 5574, correct?
Um,
And HB 1647?
I know, I put the bill number, I apologize. It is, yes, 5574 and 1647. So, like I said, that is still on, the books, it's still alive for this session, but what we are, expecting, is, in terms of new legislation, is a narrower bill, given all of the practical realities that Pam and Nancy mentioned, everything else happening this session, and a short session, et cetera, et cetera. So we're hoping to advance one that would at least provide that 12-month coverage, like Oregon and California have. So some of those details are still being worked out, so I don't have a bill number for you on that. In terms of covering other populations, the second bullet is about a bill that our allies at Northwest Health Advocates have been working on, Medicaid suspension for justice-involved populations. And that is, the issue here is that there are 28,000 folks who were released from incarceration every year, and what happens to them if they were on Medicaid before is that they are terminated when they become incarcerated. They get covered elsewise while they are there. But then there are problems in getting them back enrolled, and they are, people are not prioritized for getting re-enrolled if they have children or families to return to, and so we think at a minimum that would be a great step, is to make sure that there's more seamless coverage, that there isn't this churn, and that if you just suspend their access to Medicaid during the period of incarceration, that would really make it a lot easier. And 21 other states already do this, so we're supporting that legislative effort, because we recognize that that's, again, a really underserved population in terms of healthcare access, or folks who released from incarceration. Okay, so the other two bullet points are some of the anticipated defense, and you're absolutely right that we could very well see some efforts at state Religious Freedom Restoration Act as well. We heard talk of it last year, certainly happening elsewhere. And again, that would be those kinds of, sorry, I should have put that bullet point there, but those kinds of efforts are really dangerous because they purport to just expand or to restate religious freedom that exists in our Constitution, but what it would do would be potentially to expand those rights and affect not just health and reproductive rights, but also our anti-discrimination laws that provide for anti-discrimination, particularly I'm thinking of LGBT folks in public accommodations. So that is something we're definitely keeping an eye out for. Again, some other bills that are still pending and alive from last session, parental notification bills. We have seen these pretty much perennially, but what I'll say over the past few years is that we are starting to see them actually gain some footing and make it further in the process than we have ever before. So in fact, the Senate bill did make it out of committee last year and didn't end up getting a full vote by the Senate, but that's, in the dozens of years that it gets, similar bills get introduced, that's the furthest it has made it. So we're definitely keeping an eye on those. And we also saw all kinds, if you look at our legislative update, which is on our website from last year, we saw all kinds of anti-choice bills being introduced, things like establishing fetal personhood, eliminating lawsuits for wrongful birth, and all kinds of things that have potential impacts on choice. Again, we didn't see most of those advance very far, but we are seeing more progress on this. So a lot of our work will be spent on doing defense. And of course, the last one is really about, unless you've been living under a rock, you've heard about all the allegations, false allegations made against abortion clinics and their treatment of fetal tissue. And so that has really, I think, been part of the conversation. Unfortunately, in the focus in many legislatures around the country, we're seeing states trying to cut Medicaid funding to Planned Parenthoods, launching investigations. So happy to say in our state, the Attorney General, I think it was 2 weeks ago, issued the results of his investigation, finding no concerns at all rates in our state. And, you know, that's not to say that some legislator might not come up with something else. Because again, they're not a surprise to us in terms of what we have to defend against, because they're models that are passed around state to state, and so they're, you know, they fall into certain categories. So we expect to see some of those and do some work on that. One other thing I'll just mention that sometimes gets hidden is a lot of the wonderful defense work and just that is successful, and the things that we don't see here in Washington. And just one example is telemedicine. We have seen in general in healthcare the advance of telemedicine practices, which is the idea that the provider and the patient do not, for all types of healthcare services, necessarily have to be in the same physical place, right? So there's things that have been happening over the years. There's some states allow requirements that allow these services as long as they're in video communication or different requirements. But we're generally seeing this trend towards increasingly allowing telemedicine, which I think is a good thing for healthcare access. But what we are often seeing is attached to those efforts, this carve out again for guess what, for women's health, for particularly targeting medication abortion often, because that is something that can be done very easily. It's pills. You do not need to be in the same physical place for that. And we did see in Washington a telemedicine bill pass, and it passed without restrictions. So I just want to shout out our lobbyists and other folks who make sure that some of those bad things don't get put in bills where they don't belong. That's it on health and reproductive rights. David.
Okay, I'm going to talk about our priorities on violence against women issues. We had a very good session, as Pam and Nancy discussed last year, on violence against women issues, which we are hoping will be the case again this year, although we are getting into some bills that have had bumps along the road in past sessions. The first bill I want to just discuss is House Bill 2033. It would be designed to make some what we consider very common sense and not huge changes to Washington's sexual assault protection order statute. Sexual assault protection orders are civil orders. They're like domestic violence protection orders or other types of restraining orders that you can get in court based on a preponderance of the evidence. They're not criminal cases, and they're basically stay-away orders that say, in the case of sexual assault protection orders, that say if you've been a victim of sexual assault, you can get an order, or you should be able to get an order that requires the perpetrator to stay away from you. And the bill that was introduced last year would make two changes. It would say that sexual assault protection orders can be issued permanently. Right now there's a 2-year limit on a sexual assault protection order, which is not the case with domestic violence protection orders or some other types of protection orders. Another change the bill would make would actually establish a process where you can renew a sexual assault protection order that's about to expire. The statute right now doesn't have the standards, so courts really are all over the map on what standards they might apply in deciding whether to renew a sexual assault protection order. The bill passed the House last year with bipartisan support. It made it through committee in the Senate, but then it never got brought to the Senate floor for a vote. So we are going to be working with our allies at the King County Sexual Assault Resource Center and the Washington Coalition of Sexual Assault Programs to try to get the bill through the Senate this year. The bill was initiated last year. The King County Sexual Assault Resource Center has been working very hard on this for well over a year. So we are going to add our lobbying strength to the bill this year and hopefully get it through. The next bullet point, we don't have a bill yet on this, but 2 years ago, Legal Voice, along with Washington Coalition of Sexual Assault Programs, worked together on a bill that was introduced in the legislature that would establish some clear processes and rules where a survivor of sexual assault who becomes pregnant as a result of sexual assault is able to restrict or terminate the parental rights of the perpetrator. There are not clear rules on this in Washington right now, and we are becoming actually a dwindling minority of states that have not legislated on this issue. The big issue I think that has been a hang-up in the legislature on this is various states have taken different approaches on this issue. Some states will allow termination of a rapist's parental rights only if there's been a conviction for rape. And we know that rape is still one of the most under-prosecuted and under-reported crimes. Less than 5% of rapists ever spend a day in jail or are convicted. So the approach that we have taken is that we believe a bill should allow a process for terminating parental rights of a rapist if you can prove by clear and convincing evidence that a child was conceived as a result of sexual assault, and not to require a conviction. And that's the approach that a number of states have taken, ranging from Texas to Illinois. So we have, what we think of as red states and blue states have taken that approach. And this year, Congress put a little thumb on the scale towards the approach we prefer. Congress managed to pass a bill this year. I didn't know that, but they did. The bill included a provision that increased states, it would make states eligible for 10% more funding under the Federal Violence Against Women Act if they enact a law that allows termination of parental rights of a rapist based on clear and convincing evidence that the child was conceived as a result of sexual assault. The approach we've taken, and not to require conviction. So we're hoping that will give the legislature a bit of incentive to move on the bill, because there had been concerns expressed during the hearings that were on the bill 2 years ago that a conviction had to be required. But Congress, by a very strongly bipartisan manner, rejected that approach when they passed this legislation, and a number of other states have. So we believe the bill could get some added momentum this year. Part of the problem too, though, is it's a short session, and this is a bill that requires a lot of education with legislators about to understand the issues. There's still a lot of misconceptions, as we know generally, about sexual assault, and there are people on both sides of the aisle, who have concerns about not making it a conviction-only bill. But I think we have the good arguments on our side, and now we do have the help from Congress on that. The third issue I want to talk about is we're not aware of a specific bill this time, but we are thinking there may be some legislation this year that would try to extend statute of limitations for prosecuting sexual assault in Washington. We don't have particularly long statutes of limitation for sexual assault crimes in Washington. If a rape is not reported within a year, there's a 3-year statute of limitations from the commission of the crime. And in most other cases, there's a 10-year statute of limitations for prosecuting rape. We think, especially in light of the fact that there are still sitting on the shelves about 6,000 backlogged rape kits, some of which are approaching deadlines for statute of limitations, that this would be an opportune time to do what a lot of other states have done and extend the statute of limitations for prosecuting rape. Many states are 12 years, 15 years, and some don't have any statute of limitations for prosecuting rape. And we think that Washington, we would support efforts to extend statute of limitations here in Washington. And I think that's, we are not aware of any bills at this point that we're going to be looking to defend against in the violence against women area, but something always pops up. So we will keep you informed if any bad bills pop up. I'm going to turn it back over to Janet.
Okay. All right, well, I think there's some better news on economic justice in terms of being able to be proactive, and it's actually felt like a very exciting time, because we, at Legal Voice, of course, have been talking about these issues for a long time, but I feel like we're seeing them catch on a bit more, not just in our city, in our state, but elsewhere around the country. So again, it always helps to for me to look back and say, well, I feel like we've been talking about this forever, but we are making progress. So I'm gonna take these a little bit out of order and start with the paid sick and safe days and family medical leave insurance as two of the ones that you've probably heard us talk about before. You're like, yeah, I know all about these. Well, so again, these are both bills that have been introduced before. They are currently pending in the legislature because they're carryovers from last spring. Essentially the paid sick and safe days bill is modeled after the one that passed in Seattle and has been in effect for 3 years now. A study has shown, they conducted a study, commission study by the city that showed that it really had not had adverse effects and had good effects in Seattle, and so that has been really helpful in getting the state bill more support. We also have seen in the meantime, since we first saw paid sick and safe days bill at the state level, other cities, Tacoma passed a bill as well, and there are efforts in Spokane and Bellingham and Walla Walla. They're starting the conversation as well. So we're really seeing this those who maybe aren't as familiar with the Safe Days concept, because please, and feel free to ask if any of this is lingo that we sometimes are a bit too glib about, because we want to make sure people understand what that means. And what, paid sick days, of course, is the idea that you don't get fired just because you have to go to the doctor, your kid gets sick. Those are more the routine illnesses, right? Or just health, preventive care. That everybody should be insured a certain number of hours or days that your job is protected when you need to take leave for those reasons. And we see that actually most people probably in this room, in the private sector, at bigger employers have this. So it's often the people who are in much more tenuous employment situations, part-time, or low-income workers who don't have the same guarantee. So the Safe Days piece has to do with providing that similar job-protected leave for folks who need to take time off to address domestic violence, sexual assault, and stalking. So everything from getting legal assistance, getting medical care, moving your home, all of those, getting counseling, all of those kinds of activities. Currently under Washington state law, workers are protected for those activities in terms of getting leave, but it's unpaid. So this would kind of add to that and incorporate it. Really, again, in the concept that if we're talking about a healthy workforce, we're talking about all of those kinds of health needs, and safety is one of those. So anyway, just wanted to explain that piece of it. So that bill again is on the books, and we anticipate advocating for that. And the family medical leave insurance is different. People sometimes confuse that. It's whatever, sick days, medical leave, but that's really the FMLI. Family is our shorthand, catchy term for that bill. I know it's too clever by half, right? But anyway, there's also Federal Healthy Families Act that is similar to that. I may have the phrases wrong. Anyway, family bill is what the state bill is called, and it's again to ensure some form of income protection for folks who have the more serious health conditions, or for new parents, whether by adoption or by birth, or fostering as well. So that is to cover that. And again, we have on the books actually in Washington a limited version of this that passed back in 2007. It had got stripped down to just providing wage replacement for parental leave. It never got funded, but that was kind of the high water mark of the past efforts. And so this bill really re-envisions that in terms of the funding. It would come from both employees and employers paying into a fund, be administered similar to by the Employment Security Department, which runs our unemployment compensation program. And that, like I said, we've been talking about for a long time, but the exciting news is this year Washington State was a recipient of one of the grants by the Department of Labor to do a study on this issue, and I think one of only 5 states, maybe even fewer states in the country to get that kind of money, and it was something like $200,000, not enough to fund the program, but enough to give it some momentum. We're also hearing of interest in potentially a voter initiative on, I'm sorry, I'm mixing my topics, going back to paid sick days, in Tacoma, CTAC, there was a paid sick days and minimum wage initiative combined. So there's a lot of, suffice it to say, a lot of discussion and interest at the legislative level and potentially on the ballot as well. Okay, that was supposed to be fast. I'll jump to the ones that we've been really actively working on that are newer. The Equal Pay Opportunity Act also debuted last spring, and it will be back, and we've been working very hard in the interim on addressing concerns that some of the opposition had business. And essentially there are two aspects to this bill. There's a fair pay piece that would strengthen the remedies under our existing Equal Pay Act in Washington. Right now, the remedy for violating our Equal Pay Act is it's a criminal misdemeanor. Yeah, so never gets enforced, and rarely is used in litigation. People, you can still sue under the Washington Law Against Discrimination, but what this bill would do would be to increase the remedies, add administrative enforcement. And the thing is, a lot of these pay differential cases, equal pay cases, there some cases there isn't a lot of money involved. So, in some cases there is, right? Depending on how much you're making in the first place, those hours can add up. But, what this really, I think where the gap really is in terms of people having access to this law is for the lower wage workers again, because they aren't going to be able to get attorneys often to represent them in these cases where the damages are quite small. So if you add administrative remedies, it gives them a more meaningful access to make that kind of claim. The other big piece of the Equal Pay Opportunity Act, actually two other big pieces. One is that it would, our bill as written would cover not just pay differentials based on gender, but also differentials in job opportunities. So this idea of career tracking, that folks sometimes, the classic example we've been using is in the grocery industry, you have meat cutters who are more highly paid and tend to be male. And then you have the meat wrappers who are women, and guess what? They get paid less. What is it that goes into that that segregation? So this bill would also seek to remedy that kind of tracking that happens often because opportunities are just not made clear. So that is how that bill would address that. The other big piece is that it would seek to prohibit pay secrecy. So what we know is that the wage gap is a real thing, and that there are lots of things that go into it. And one of them is simply lack of information, that people don't talk about their wages. We know that in public employment, it's a matter of public record what people make, and there actually is a smaller wage gap in those kinds of jobs. So that is one piece of this, is that it would prohibit employers from requiring employees to sign non-disclosure agreements, and would prohibit retaliation against employees who share information about their pay. So that piece is pretty simple, and like I said, it's been proven to be effective elsewhere. Okay, so that's it for the Equal Pay Opportunity Act, and like I said, we are hopeful we did get some bipartisan support last year, and I'm hoping to gain some momentum on it this year. The Pregnant Workers Fairness Act is a new one for Washington. We're really excited about this. We're working with a couple different organizations on this, and it is been passed in a bunch of other states, and it's essentially getting at this problem where pregnant women often what is preventing them from being able to work is just something that would require minor accommodation. So say you were required to wear a uniform, and they won't provide you a uniform that fits you as you expand. Or you need more frequent breaks to take a drink of water, or you need to have access to something to sit on now and then, depending on your job, right? So these seem like minor things, but they often are the reason that pregnant women are not able to continue working. So the idea here is, not so much that this is in fact, we are trying not to talk about it in terms of a disability accommodation, because being pregnant is not a disability, but it's to ensure that these kinds of small accommodations will make sure that people can continue with a healthy pregnancy and not develop a serious medical condition. Ironically, in which case they would be covered and protected. So hoping to not develop into that. So that's what this bill would do, is to allow workers access to those accommodations and protection when they ask for those. So again, the concept of accommodation is well known to employers because they have to do it under disability law. And we've seen this similar type of bill came out at the federal level, because yes, Congress, but actually in a lot of other states, including most recently, I think it was Nebraska, right? Megan's been helping with the research on this. And yes, kind of unlikely states are actually seeing movement on that. So we're very hopeful about that bill. We don't yet have a bill number, I think, for that, but we hope to see that move as well. I think that's it for our economic justice agenda. Just a few things.
Okay. So I'm going to talk about just two more remaining issue areas where Legal Voice does advocacy work. Family law has been something Legal Voice has worked on since its founding, and we are one of the few organizations organizations in the state actually that maintains an active lobbying presence on family law issues. The Washington State Bar Association's Family Law Executive Committee also often weighs in on family law issues. There are organizations which we sometimes call Mad Dad organizations which weigh in. We exist in Olympia on family law issues to represent the perspective of women as well as LGBT folks who are parents and deal with making sure fairness for everyone in family law. This year, the one bill I think we're definitely going to be monitoring is we're expecting there will be a bill introduced on child support issues. Under state law, every 4 years, there's a child support schedule work group that has to be convened. Federal law requires this, that our child support schedules be reviewed every 4 years by our work group. Legal Voice does not sit on this work group, but we do have good allies who sit on this work group, including Civil Legal Aid has a representative on it. And there's custodial parents, non-custodial parents, a big group. They very rarely can agree on much, but this year they did agree, again, that the child support schedule in Washington should be updated to be based on more current economic data. You know, it sounds very esoteric, but over 300,000 children are supported through child support orders in Washington. It's a huge economic justice issue. And right now, our economic table for determining child support obligations is based on data that no one on the work group can figure out where it came from when it was adopted in the early 90s. And so we believe it would be important to update the economic table so it's based on current economic data. Another issue with child support, which may be getting somewhat esoteric, but it's very important, is we've been constantly monitoring to see what the legislature might do with what we call a residential credit, where a child support obligation of the non-custodial parent is reduced by the amount of overnights that the non-custodial parent has with the children. We're always very concerned about this because we do feel if it's too rigid a formula or if it's too mandatory a formula, we will see people trying to get more overnights simply as a basis to reduce their child support obligations, not exercising the visitation and leaving the custodial parent, who is still most often a woman, with less money to support her children. So we'll be monitoring that. The work group this year did not recommend a mandatory residential credit formula, which we were happy about, but they did recommend a formula that would be used in cases of deviations from the child support order that I frankly have tried very hard to understand, and I still can't understand how the formula works, and it would in many cases, we believe, result in custodial parents being left closer to poverty, and Civil Legal Aid did express concerns about the formula as well too on the work group, so we'll be monitoring that closely. I expect we're going to have to go back and testify again this year on what we call paternity disestablishment bills, what the supporters call paternity fraud bills. And these are proposals that have been introduced in Olympia the last 2 years. Right now in Washington, if you're presumed to be the father of a child because you're married to the mother, or if you sign voluntarily an affidavit acknowledging that you're the parent of the father of a child, you have up to 4 years to challenge the fact that you're a father based on the presumption or the signing the acknowledgement. And the reason we have a 4-year time limit is to ensure some certainty for children, that they will not lose parent-child relationships, after 4 years. Bills have been introduced the last 2 years that would remove that 4-year restriction on challenging a paternity order, so that paternity can be challenged at any time in a child's life, whether 12, 15, 18. If a genetic testing shows that the person who signed the paternity acknowledgement or has been presumed to be the father of the child is not the genetic father of the child. We've shown up the last 2 years almost alone to oppose this bill, but we've been successful in keeping it from passing. We do know that there have been concerns expressed by this bill against by other folks, many of our allies, and we are hoping that we'll have a better turnout this year in terms of if there's a hearing about having some stronger opposition to this, because the people who are pushing this bill, they say it's unfair that I should have to support a child who is not mine. And our view at Legal Voice has always been that paternity and parentage is not a matter of biology, it's a matter of acting as a parent, and that's important to children and it's important to families. So we'll be be watching those bills again this year. Our opponents had T-shirts last year, and I mean, we come up with T-shirts ourselves this year. Stop paternity fraud T-shirts, so I don't know what, maybe we can come up with something on our
Just
own.
establishment is not part of this.
Mostly like second wives.
Yeah, you are correct on that. And I did also want to touch on LGBTQ rights. Legal Voice has always been very active in Olympia on advancing LGBTQ rights. This year, we're not expecting a whole lot affirmatively. There's a possibility there will be renewed efforts to pass bills. This is going to be a mouthful, to address sexual orientation and gender identity change efforts. This is more commonly known as conversion therapy, where somebody who is a medical provider says they can cure somebody from being gay or lesbian or transgender. It's junk science, it's not healthcare, and it's actually very dangerous, and it's been discredited by every major medical association. And five jurisdictions now have banned the use of this on minors, and we are hoping Washington can become the next one. Unfortunately, there have been roadblocks on this in getting it through the Senate in the past couple of years. It has passed the House twice, so we'll be monitoring that to see. It may be that it's just still not possible to get it through given the political environment in the Senate. And then I think Janet mentioned this earlier. I mean, we just are going to be very vigilant about opposing any efforts to weaken existing protections for LGBTQ people. There have been bills introduced over the years. A couple of years ago, there was a bill introduced directly in response to the Arlene's Flowers case, which I think many of you have heard of, where a florist in the Tri-Cities violated Washington's anti-discrimination law by refusing to serve a same-sex couple for their wedding. There was a bill introduced a couple of years ago to push to change our public accommodation laws so that would be permissible. It didn't go anywhere, but as you know, we're always, with LGBTQ rights, I mean, guarding against backlashes are always important. Last year, you might have seen what happened in Indiana with their version of a Religious Freedom Restoration Act, which was defeated, and that's good news. Similar bills were defeated in Arizona, but we have to expect that in Washington and be prepared to show up in numbers if there's any efforts to do that. On transgender rights, which is an area of the law that we've been doing an increasing amount of work, we'll also, I'm sure, be looking to defend against any efforts to pass what are so-called bathroom bills that would say that somebody has to use the bathroom that conforms to their biological sex or their chromosomal sex. Under Washington law right now, it's interpreted to mean that people are allowed to use the bathrooms or locker rooms that conform to their gender identities. Not looking at chromosomes, we're not having bathroom police or genitalia police at each bathroom to make sure you're using the correct one. But there are growing efforts in some states to pass those kind of bills. The good news is they haven't had much success yet, but it's an issue that some of our opponents have seized on too. Yes?
Is there any thoughts for proactively pushing legislation to require non-gendered bathrooms?
Well, after what happened in Seattle, the Seattle City Council, of course, passed an ordinance this year that addresses some of the bathroom issues, which say basically if you have a single stall restroom or a single usage restroom, it has to be designated that either gender can use it. There's not an M or a W on the walls anymore. And also makes it very clear under Seattle city law that people have to be able to use the bathrooms that conform to their gender identity. At the state level, I don't think there's been, I'm not expecting a bill on that this year. I'm not sure, actually, California I think has passed a good bill on that, but California in some ways is still quite far ahead of us in their ability to move proactively on that area. But it's a huge issue for the transgender population. It's also a big issue for people who are disabled, who may not be able to, may need some flexibility in which bathrooms to use. So we'll be watching those. I think, I can't believe it, but I think we have finished, well, 5 minutes early. All right, so, but I did want to put on the board, if you are, want to sign up for Legal Voices legislative updates, here's some information about how you can do it. We also have a sign-in sheet here, and about every 2 weeks during the legislative session, we send out our legislative updates, and they're very long, they take a lot of work on our part, and we hope folks like it. I did want to offer the chance, not to put Senator Chase on the spot, but if you would, since we have a few extra minutes, would you just like to introduce yourself to folks and give
Sure.
your...
I'm Marilyn Chase. I'm a senator from the 32nd Legislative District. I've worked with Legal Voice for caseload increases, not anything else, caseload increases. We're going to see more attempts, I think, to go after what we call budget shifts. And when we talk about a down payment on Cleary, it was accomplished mainly by shifting all the money out of the Public Works Trust Fund, which gives us clean, water and bridges and sewers and roads and stuff. It's very important. And so we can expect to see more shifts, I think, in the legislature, because you can, it's robbing Peter to pay Paul is what's going on down there. And we're very concerned that they're going to go after the meager supports that we have for women. No question they're going to go after anything we spend money on LGBT. It is going to be a tough session. And I took an apartment for 6 months. I've been told people want to get out and campaign. So who knows? It is going to be probably the hardest, nastiest session we've ever had. And believe me, it's coming from places you would not expect. But I do think that, just so you know, Senator Patton, who chairs the Judiciary Committee, is adamant on stopping trafficking, which surprises me, but I think that we can use that for some of these other issues that I thought, oh yeah, he can be our ally on punishing rapists and that kind of thing. So all is not lost. All is not lost.
Thank you, Senator Chase. Yes. So, yes, we do have time for a couple questions. We'll stick around too if people want to catch us afterwards. Yes.
I attended one of the listening sessions that the senators had going around the state talking about the Cleary situation. And down in Renton, there were about 300 people, stayed several hours overtime, tremendous groundswell of anger and insistence that the legislature do something about raising taxes, getting away from being the most aggressive tax system in the country. And also there's talk now that looking at the Iman initiative as an opportunity to do that now, raise those taxes, cut the sales tax, bring more money in, and not have to go the initiative route. I think it's opening before that happens or before that door closes again. Will we be involved in any of that lobbying? Because I know they're going to be pushing for it. The community and particularly the PTAs and the schools are extremely strong and concerned about that.
We've been part of a revenue coalition of like-minded organizations who know that we need a sustainable budget and funding stream for the important values that our state has in terms of serving its residents. So I anticipate, I don't know, I haven't heard that we're formally getting together yet. I would like to see a groundswell from the people. What district are you in and where did you attend your meeting?
I live in Seattle, I went to the one in Renton, but from what I read, people were pretty outspoken all around the state.
That's very, that's, yeah, of
Yeah,
course.
I've been introducing an income tax bill every year for several years. And about 2-3 years ago, I started talking about the income inequality, and I had charts that showed that poor people pay 16%, down to rich people pay 2%. Nobody was listening to me. I was ridiculed, and they just poo-pooed it. Now, every place you go, people talk about the fact that we have a regressive tax structure in this state, and that to me is really encouraging, because I think we lost our income tax initiatives in the past because we did not plow the ground. People didn't know what our tax structure was, and I think the coalition that you mentioned, Pam, is doing a great deal to help educate the people. I don't want us jumping again into an income tax bill until everybody in the state understands, that they're paying more than the majority are paying way more than their tax, fair tax burden. And I think that will be the tipping point. When we get to that, we can get our income tax. But until that time, we're not going to get an income tax.
Yes, Karen.
How can I make a donation to support your fine work?
Michelle.
Cindy?
have donation envelopes here too, but yes, well, we can always do it online, at legalvoice.org.
Swear.
Yeah.
Thank you.
So on, page 1302, is there any language on human trafficking in there as well for the victims?
No, that was a bill that we tried to do a fairly narrow fix of a flaw that was in our criminal custodial interference statutes. So it was not really an anti-trafficking bill. It was meant to address a very clear problem that had come out of what we considered a very bad Supreme Court decision, where they said you couldn't be charged with criminal custodial interference if you withheld access to a child under the terms of a domestic violence protection order that gave residential time to the survivor. So, but it's not trafficking.
And then the rape kit,
Yeah.
bill, is that one in line with other states? I worked with Senator Carroll's office in Colorado.
Oh,
And
okay.
she's willing to work with Washington State.
Oh, that would be, yeah, these state connections, because, yeah, in the state legislative arena, yeah, so much of it is what has other states done, what have other states done, what are good models. Colorado actually did a very good job on addressing terminating parental rights of rapists. And they had a work group that looked at that. We've actually gone to the Colorado website to get a lot of information on that. Well, thanks. I can't believe we're right on time, so thank you, everyone.